the Article 32-1 talks about when a teacher agrees to perform work for the district. There's no indication, and actually the Court of Appeals expressly found that there's no indication that work for the district includes work or education that a teacher has to participate in to fulfill a baseline qualification of the job. This is the sort of gap that requires the Management Rights Clause to apply, because if this wasn't a collective bargaining agreement and there were no Management Rights Clause, this would be the kind of thing, and it's the same thing that Justice Hart was asking me about, where it could be susceptible, and I think that's what the Court of Appeals found, that you could call any kind of education that a teacher completes to further their career professional development, per se. You could call it in-service if they participate in the education while they're working for the school district. But the problem is, in this setting, and collective bargaining agreements are unique, especially those with management rights clauses. In this setting, in order to, if there's a claim that coverage under the agreement, if they have to, if you have to bend it, if you have to make it, try to make deductions in order to fit it in to one of the express terms of the agreement, then it's out. I think some of the cases that we cited, and I think they'd also be helpful to answer some of Justice Hart's questions, show you how this rule actually works.
So I'm troubled because you keep going to words like tortured and bending. I thought I asked a pretty simple question. If a teacher is required for his or her job to get this training to teach, why isn't that work performed for the district? And if they're doing it off on their own hours in the summer, why is that not compensable? My concern is, under your reading, it's what Justice Hart asked you, that if they don't mention ELA or this or that or something else, they are out of luck. So I guess Article 32-1 should be about 70 pages long and mention every single thing a teacher could do, or they're out of luck. That's my concern about your position. I
understand your position, but
it's not my position. I'm asking about yours.
Well, I think I would disagree with that. I think that's incorrect. I think what that position that you're asking me about, I think that's exactly what I was talking about in my opening, about flipping the dynamic of collective bargaining on its head. The issue is that the employer starts out with all the authority, and it's only constrained by express provisions of the collective bargaining agreement.
And so why is it not, I'm sorry to interrupt you, why is it not accurate then that unless they list every possible job task that they could do beyond the work week, you get to say it's not covered? That's how, I may be misunderstanding your position. If I am, I'm sorry. But that's what it sounded like. If it's not specifically listed, they're out of luck, so it's their job to come forward and make sure it's everything they possibly could do is listed. That doesn't make sense to me.
Well, it's not true, is the reason why it doesn't make sense to you. If you take a look at page 9 of the response brief, DCTA's brief in this case, they listed about 6 or 7 professional development trainings that were compensable. And looking at them, you're able to easily distinguish them from essential eligibility and qualification requirements of a position. There are things like guided reading, for example. These are real programs, legitimate programs that the principal has required the teachers to participate in, or ask the teachers to participate in, to benefit or improve things that are happening at that school. For example, you can, if you don't go to these professional development programs, okay, you may be insubordinate if you're ordered to, and that's a different problem and handled under a different law. However, if you skip the program on guided reading, that doesn't make you ineligible for the position. That's really the distinction that I'm trying to get at here. Whereas if you skip the ELA training, you can't be in, if after 2 years go by, which is what the consent decree requires, and you don't complete this training, then you can't be in the classroom. That's an essential job qualification that's referenced under 13-2. And I hate to keep coming back to it, but if it's exactly what the Court of Appeals said in although it didn't reach the correct result, but it said that there's nothing saying that the work for the district includes the work that the teacher has to do to meet the posted qualifications for the job.
So would the example you gave and what they cite, would that be work for the district? Is it because the principal asked? Is that, I'm just trying to figure out how that fits in with the collective bargaining agreement. So which article are we under in the example you just gave?
Well, that 13-2.
Okay.
And that's what the Court of Appeals, they looked at that, but they also specifically looked at the article you were asking me about, 32-1, where they sort of latched on to that and they said, there's no indication that fulfilling essential job qualifications is included in the additional work for the district that's discussed in Article 32-1. And when you have a management rights clause, the answer is when it's not included, it's out.
So could you give me an example of what would fit within 32-1?
Well, for example, if we decide to have an extra school day and we extend classes by a few days in some schools, that fits. We're requiring you to come and do additional work for the district. That fits under Article 32-1.
Well, teachers who are going to teach English language learners are required to have ELA training, right? I think this distinction you're drawing, if I can borrow a word, seems somewhat tortured. I just don't understand why ELA training isn't in-service training, in-service education, which is specifically included in the CBA.
Because it relates to the baseline job qualifications referenced in Article 13-2. If I could address one case by a Supreme Court in a neighboring state in Nebraska that kind of shows you, and I think if it shows you kind of the difficulty of some of the realities about interpreting these phrases and following these rules in collective bargaining agreements. In Nebraska, there was a collective bargaining agreement, and there was a wage schedule where it began with START. And it went up from there, START, and then step 2, et cetera. The county in that case hired an employee and they hired a lateral employee, and they started him or her in the middle of the salary schedule. The union grieves, saying, no, the collective bargaining agreement says START. And what the Nebraska, what the union did in that case is that they threw exactly what's being thrown at you here, the dictionary definitions of the term START, okay? And the court had to say, well, is it ambiguous that is the word START in the collective bargaining agreement susceptible to more than one meaning, i.e., could it mean everybody starts at START, or this is just the start of the range? And I think if in that circumstance, even if we weren't in a collective bargaining agreement with the management rights clause, you'd have a point. I mean, it is susceptible to either meaning. But what the court held is because you did have a management rights clause, and there was nothing in there saying, nothing in the collective bargaining agreement expressly saying that the word START in here means that everybody who comes into the county has to start at START, that the management position prevails. And so that's why, I mean, the difficulty you're having is undoubtedly an argument that was made to the Nebraska Supreme Court in that case, where they're saying, Justice, it says START. How does START not mean start at the beginning? And I see your point. I see that position. However, they lost, and in the other cases we cited with collective bargaining agreements, with management rights clauses, they lost too. There's another case published case out of the Oregon Court of Appeals where there was an argument about whether the term teacher discipline included teacher dismissal. And you're thinking, well, isn't dismissal the ultimate form of discipline? I think it's the same kind of arguments that you're throwing at me here. It's that where there is no express requirement to fill in an ambiguity in the way that a claimant wants to, then they can't prevail in a collective bargaining agreement where there's a management rights clause.
I think, well, I haven't heard the argument yet about why taking that reasoning, the school district couldn't say Common Core training doesn't count as in-service training because it's not specifically listed as part of in-service training.
Because it's not a requirement to the effect of a teacher licensure, for example, or the ELA training required by the consent decree. It's just different. I mean, if we go down the road of saying that there's an ambiguity here, then it's an example that we gave in our opening brief that was never contradicted, is if a teacher comes in with a claim to say that I did this professional development on my own, it's called professional development, I did it to keep up my teacher license, and they put in a claim for compensation with the district, I think that if you go with the analysis that you're saying, of course it's professional development, then you're creating a slippery slope that requires the school district to compensate somebody for that training, that baseline eligibility, qualification, education that teachers are just required to do as a condition of their employment. That's really the difference.
Can I ask how, so just again, coming back to 813, because what you just described clearly wouldn't fall under 813, because that's the teacher going on a frolic and a detour for some professional development. But with the ELA training, how does it get set? Who says, here are the ELA trainings that will work for meeting the training requirements?
Are you asking whether the district coordinates?
Yeah.
It? And the answer is yes.
Okay, so it's district-coordinated training, but it's not professional development or in-service training.
Well, it's not compensable professional development or in-service under the agreement. Yeah, I mean, we're getting really caught up in the labels here, and I think that's what you can't do. I mean, we're sort of elevating form over substance here when we're saying that you can call, for example, you use the dictionary definition that the DCTA gave you to say that professional development for teachers means education they do to promote their career or something like that, okay? But the collective bargaining agreement draws a distinction between job qualifications and compensable, fulfilling job qualifications and compensable professional development. Else, why would we have Article 13-2? I mean, it's in there for a reason. It's that teachers have to meet the essential qualifications that are required, these baseline qualifications that are required for their job, and it's on their own dime because it doesn't say that we have to pay for it. To answer Justice Gabriel's question, if the DCTA wanted to negotiate for this type of training to be compensable, they don't need a 70-page list, but what they need to do is in Article 13-2 indicate that something along the lines of when a teacher does work during the school year to meet these requirements, then the district has to pay an in-service rate. I mean, that's how you negotiate that. That's what's not in there, and that's why the district's position prevails on this.
Okay, just one more question, then I'm going to shut up. But
Okay.
So the 13-2 mentions accreditation standards of the Colorado Department of Education. And I asked this before, but I just want to be sure I'm understanding. To meet the CDE's accreditation standards, does a teacher have to keep her accreditation or his accreditation? Does a teacher have to do a certain amount annually, biannually of professional development?
It's not in the record, but I think the answer is yes.
Okay, so there are some accreditation standards in 13-2, some requirements in 13-2 that are also encompassed by 8-1-3.
No, I won't go there because the 8-1-3 discusses when professional development is compensable. And so that's a different, you could call it professional development, but you cannot fit the ELA training into the subparts of 8-1-3. So if that answers your question, I would like to save a bit of time for rebuttal.
Do so.
Good afternoon. My name is Sharon Dreyer, and I represent Denver Classroom Teachers Association. There's no conflict at all between the Denver firefighters' decision, including its language about management rights clauses, and the result in the present case. Denver firefighters says that management rights clauses mean that the rights retained by the city or the employer under the agreement are constrained only by express terms to the contrary. And Denver firefighters says that where an agreement is silent with regard to a specific management right, we assume that the employer has retained authority over that right. In the present case, the collective bargaining agreement is not silent as to the management right of requiring teachers to take training without any additional compensation. And the CBA here expressly modifies that right by expressly requiring the district to pay compensation for trainings that are taken outside the work week and the school year. No, it's our position both that the language in Denver firefighters is dicta, as I argued in my brief, but it's also our position that even if it's not dicta, there's no contradiction between the result in this case and the language in Denver firefighters. I'm prepared to discuss the dicta issue, or I can just go right ahead into continuing to discuss the language of firefighters and why there's no conflict. And I guess I would go into the dicta if I thought that was a worthwhile use of my time, and I guess.
I think it'd be more productive for me to cut to the chase.
Okay, thank you.
I mean, others can disagree.
As I said, the collective bargaining agreement is not silent on this issue. It expressly states that any time a teacher agrees to perform work for the district beyond the work week or school year, the teacher will be compensated as described in Article 32. And then there's another provision that also says that there is an expectation that teachers will attend beyond the contract year for professional development determined by the principal if the teachers attending are paid in accordance with Article 32. Now, these provisions don't specifically mention ELA training, but they also do not specifically mention any type of training or any type of educational program that might come within the scope of those terms.
Could you, before moving on too far where you're going, follow the next step in accordance with Article 32 and explain why the ELA training is something that should be compensated in accordance with Article 32?
Well, first of all, because of the plain language of both of the provisions that I just read, state that training that's taken outside the work week, outside the school year, has to be compensated. It doesn't have any exceptions. It doesn't have an exception for trainings that are required in order to be a teacher are exempted, or trainings that you need to complete as a condition of continued employment. Those are exempted. No, nothing is exempted. It covers all professional development and in-service education. Now, the the collective bargaining agreement does not define either professional development or in-service education, although the school district claimed that the provision 813 was some sort of a definition of what professional development is or isn't. That's not the case. As Justice Hart pointed out in her questions, that provision merely places requirements. When something is professional development, these are the requirements that you have to follow, but it doesn't say anything about whether something is or is not professional development.
So is the ELA training that's offered in a manner that's compliant with 8-1-3?
For the most part, it's certainly the ELA training that we're talking about in this lawsuit is ELA training that needs to be scheduled outside the contract year. While there might be some ELA training that's taken during work time, All of the ELA training we're talking about in this lawsuit was ELA training that was required to be taken outside the contract year.
Is it determined by the principal?
The principal can make determinations about which teachers need to become ELA qualified, or the school district can override the principal and make a different decision theoretically, but it usually involves consideration of what the teacher is likely to be teaching. Although at some point, I believe the district started to require all teachers to take ELA training. But as I said, the training that needs to be taken outside the contract year is ELA training that's covered by this case. So that, as far as that requirement, that's fulfilled. I'm sorry if I didn't answer your question completely.
Well, 8-1-3 talks about an expectation that teachers will attend professional development that's determined by the principal. And I thought I heard opposing counsel say that ELA training is not generally determined by the principal.
Your Honor, I think I think sometimes it is. There are people who've been designated by their principal as individuals who need to take ELA training, and then they've been required to take it, and then there's other people who were just required to take it because all new hires were being required. But I don't think the use of the word principal is really crucial. I mean, I think, first of all, there's the other clause in the agreement which makes it clear that we're not just talking about something directed by the principal. The other clause in the contract, as you know, says that, provides that anytime a teacher performs work for the district outside the workday, they're entitled to compensation, and that doesn't have any language about the work being required by the principal or not.
Can you explain how ELA training qualifies as work for the district?
Well, it's work in the same sense that professional development and in-service education are work. And under this agreement, the provision that talks about teachers being paid for professional development then lists teachers being required to work beyond the workday and work year, and then there's a listing of the types of work the teachers can do and the rate of pay for those different types of work, and one of the types of work listed under that is in-service education. So the contract is specifically saying that in-service education is a type of work that teachers are required to perform outside the workday and the work year and is therefore required to be compensated. The collective bargaining agreement itself says that. In one clause, it uses the term professional development. In the other part, it uses in-service education. But ELA training clearly falls within both of those definitions. Since there's no definition in the agreement, what we're required to do is use the common, ordinary, generally understood meanings of the words if there's no specific definitions in the agreement.
How would you respond to opposing counsel's argument about the Nebraska case and the definition of start being something that could have meant starting base salary or starting salary for everybody, and management got to decide that because of the management rights provision?
Well, I think they got to decide it because it was ambiguous as to what it meant, and since it was not express and clear as to what it meant, then it does not, then the management rights clause would essentially trump that, and management would retain authority if there was no express limitation. In that case, as I said, there wasn't an express limitation because it was unclear what start meant. It wasn't a clear situation like we have in the present case, which clearly states that all trainings must be compensated if they're taken outside the workday in the school year. There's nothing that exempts ELA training from those two provisions. ELA training is exactly like the other types of training that the school district has been compensating teachers for under these CBA provisions. And there are basically three ways in which they're identical. First of all, like ELA training, these other trainings were not specifically listed in the agreement, but yet they were still compensated. Secondly, these other trainings, like ELA training, were required trainings. Both ELA training and the other trainings that the district pays for are required trainings that teachers must take as a condition of their continued employment in the district. If they refuse to take them, they're insubordinate, and it easily be dismissed and would be non-renewed or terminated in some manner for being insubordinate and refusing to take these other trainings. The testimony on the record in the trial was that these were all required as a condition of continuing employment.
Can I ask,
And that's-
why do you think the Court of Appeals found that the language of the collective bargaining agreement was ambiguous? You're saying now it's unambiguous,
Well-
but they're holding, and their kind of misreading of Denver firefighters, all, which I think they did misread, all kind of hinge around the idea that it's ambiguous.
Well, I think perhaps they were kind of falling for the school district's argument that just because you don't list, if you have an item that's a category, like trainings, that if you don't list each individual training under the word trainings, then that is not covered. That's basically the argument they've been making for some time, that there's no express requirement to pay for ELA training, and the agreement is silent on ELA training simply because it was not listed under trainings as one of the trainings that falls within the word trainings. And I mean, I think that does not make something silent. The fact that you don't list every item in a category does not make the collective bargaining agreement silent. For example, there are many provisions besides this one in this very collective bargaining agreement that use words that denote categories or groups of items. Yet none of these other words have listings under them of everything that falls within that category. As Justice Gabriel said, that would be absurd and unreasonable to require that kind of thing in collective bargaining agreements. So just because that's not, every item is not listed does not mean that the requirement is not an express requirement. For example, there's a provision in this very settlement agreement, in this collective bargaining agreement that says that, teachers, it says that secondary teachers, the normal caseload for secondary teachers is 5 classes per day. So if the agreement has that sentence in it, is it silent as to the normal course load for 11th grade math teachers? It doesn't mention the word 11th grade math teachers. That comes within the category of secondary teachers, but according to the reasoning of the defendant, you'd have to list every one. 11th grade math teachers, 10th grade history teachers, and list every one of them because it doesn't specifically say 11th grade math teachers, it just says secondary teachers. As another example, there's a provision in the collective bargaining agreement that says that teachers shall not be required to transport students to, quote, activities, unquote. Doesn't mention any specific activity. So does that mean that the collective bargaining agreement is silent as to whether teachers can be required to transport students to the zoo for a field trip? I mean, does it have to actually list zoo for a field trip under activities in order for that to be covered? Another example, this collective bargaining agreement says that no evaluation information may be gathered by, quote, electronic devices, unquote, without the teacher's consent. So is that agreement silent as to whether a principal can collect data by audio recording on his cell phone? It's not, because that falls within the term electronic devices.
Can I ask, can you give examples of other types of training where they are compensated?
Yes.
And
I have,
kind of
yes,
when
there's quite a
those
list.
occur?
I'm sorry?
Just a couple,
Okay, let me
so I
just
can
find that one
compare.
second. One is Common Core Standards training, student learning objectives training, guided reading, literacy, science tracks.
Can you break those down and say, when do those trainings take place? I'm trying to see if they're apples to apples.
Sure.
Is what I'm,
They all take place after the teacher is hired and working for the school district. I can't tell you for each one when it is. Sometimes different years, it could be different dates, but these trainings, teachers are told that they have to take these trainings, and they're given specific deadlines for each training that they have to take. I don't know all of them, but it's always after they're employed, while they're working for the district, they're told they have to take such and such training by such and such date. That's the way all these other trainings work.
So those are occurring during the school year?
Well, they might be outside of school time. That's why they're compensated, because they have to take them outside of school time.
Well, that was gonna be my
But they're
question.
told, for example, you have to get this one done by May 1st, or you have to get this one done by, January 31st. They're given a date, and they're required to do these on their own time, and then they get compensated for them. It's exactly like the ELA training. ELA training is not something that teachers have to take before they come to work for the district. It's not
Is there any
something-
distinction, Mr. Case, if I don't mean to put words in his mouth, but I think he would say, but it's a posted job requirement. It's a condition precedent even to get hired. That's what I think he would say. He'll tell me if I got that wrong. So is that not a distinction between all the examples you just gave?
It's not something that's required in order to get hired. You don't have to take the ELA training, and you don't have to complete the ELA training until you've been employed by the district for 2 full years. So you certainly don't have to fulfill this requirement before you start working for the district. In fact, you can't, probably, because the training is given through the district. So to say that it's a job requirement, that's a baseline requirement that you need to even get hired or to work in the district is simply not true. Now, they did put it on the job posting, and I think that was the intention. If we put this on the job posting, then we can say that it's a required job requirement that you have to have when you get hired. But just putting it on there doesn't change it into something that it's not.
Counsel, can you answer, the question that I asked about, so if we look at 13-2, the qualifications and eligibility, are there other kinds of classes that would be required, say, to maintain accreditation, which is one of the things that you have to have under 13-2 is accreditation, that are compensated? Or, because I take the school district's argument to be, we're not compensating things that you have to have in order to have this job, and under the consent decree, you have to have the ELA training.
I'm sorry, Your Honor, that's not correct that you have to have the ELA training to have this job. You can
To
work
keep
in-
the job, though.
Well, to keep the job, see, that's a big difference. The accreditation, a teacher license and valid teacher license and endorsements from Colorado Department of Education are things that you need to work even for 5 minutes. You can't be in that job for 5 minutes as a teacher or for 1 minute without those qualifications. It's illegal for you to be teaching a class of students if you don't have that license. And so you need it before you start working in the district. The district isn't going to hire you unless you already have it.
Can you give an example?
That's the difference from ELA training. That's the difference with ELA training. That's not the case with ELA training.
Could you give an example of that type of training that would be necessary for accreditation, for licensure?
Well, licensure requires there are certain educational requirements in order to get a license that you have to fill. I haven't, I don't know what they all are. And then to renew your license, you have to have, just like, CLE, to renew your teacher's license, you have to get X number of credits, between your last renewal and your next renewal.
And to get those
are
credits.
things that teachers take on their own and pay for on their own.
They are, okay.
They are, because they're things you need to be a teacher anywhere, not just in DPS, but you can't even walk in the door of that classroom if you don't have that accreditation.
So the in-service training and professional development, both mentioned in the collective bargaining agreement, those would not fulfill accreditation CLE requirements, whatever, CEE requirements?
I'm not aware that ELA training fulfills any CDE requirements. I can't say for sure that they don't, but that's certainly not the intention of it, and it's not the trainings that people take when they're trying to, renew their licenses. They're all things they go to take college courses, usually courses offered at different higher education institutions, not something offered in a school district. I'm not sure that would even qualify if it's not offered by an accredited higher education institution.
Okay.
So there's a major difference. They're trying to put ELA training in the category of accreditation, and accreditation means having a license. They're trying to put ELA training in that category, when ELA training fits in the category of all the other trainings that they pay for. Trainings that you take after you're hired, while you're employed by DPS. You can be hired, you can work for DPS for as much as 2 years without taking any ELA training, which is probably longer than some of the other trainings that they pay for. For example, Common Core Standards or one of those. I'm not sure how long you could get away without not taking that and still be employed. It might only be a year, depending on when they, require the teachers to take it. So there's no way that ELA training is a job requirement that you have to meet when you're hired. Nobody meets that when they're hired. They take it after they're hired. Maybe not even for the first year, maybe not until the second year.
Could I take you back a little bit, kind of to where I was earlier, that I'm still trying to piece together, and that's the kind of relationship between 813 with regard to the professional development training, and then the 32-1. And I guess the 813, I mean, you were saying there are no exceptions with regard to professional development, if I understood it, but it basically seems to say the teacher can be made to take this professional development as long as these various conditions are met, one of which is that the teachers are paid in accordance with Article 32, right?
Yes.
And I took it your opponent's argument was Article 32 doesn't require payment compensation for this kind of training, whether it's called professional development or whatever, however you want to do it, for the reason that it's not for the district. And so I'd like to focus on that term. And I wasn't sure I understood, Justice Marquez asked you a question about that, and I wasn't sure I understood your response. Were you saying that as long as the district requires something, it is for the district within this term?
Well,
Or how do you interpret that?
Okay, I have a couple of responses. The first response is that in 32-1, they actually tell you what they're talking about when they use the term work for the district, additional work for the district. They tell you it means curriculum development assignments, it means summer school teaching, it means in-service education, it means hourly, it means all of these things. In the express language of this collective bargaining agreement, all of these things fall within work for the district performed outside the work week and school year. So if in-service education is by definition professional development under this collective bargaining agreement, then obviously it's the determination of the drafters of this collective bargaining agreement that in-service education is for the benefit of the district, or they would not have listed it under this provision. But they've told us in-service education is one of the things that's covered.
Because they provide an hourly rate for in-service education?
Because they list it under the provision that says teachers have to be compensated for doing this kind of work outside the work year, and this is the rate of compensation. And then they list the different activities and the rates of compensation. So if it wasn't an activity that fell within the definition of work for the district, then there would be no reason to list it. They're specifically telling you these are things that fall within that term.
And do you think that can be read at all to mean these are things that might be, depending on whether they work for the district or not, and if they are, here's the rate at which they're to be compensated?
No, Your Honor, I think it means that they've decided in-service education is for the benefit of the district.
Okay.
That's what this says. It is an activity that's for the benefit of the district, just like the other ones that are listed, and therefore it has to be compensated.
And then would you point me, just because you've got this down and I don't, where do we define in-service
There's
education
no
again?
definition anywhere of in-service education or professional development in this collective bargaining agreement. And that's why I started to talk about what you're supposed to do in a case like that, and you're supposed to apply the common, ordinary, common sense meanings of those words, such as, and this is specifically in labor arbitration law, they specifically refer to reliable dictionaries as a source for defining terms that are not defined in the agreement. And the definitions of professional development and in-service education in dictionaries and the like clearly include any type of training. They clearly include ELA training. One of the definitions, I believe, was, sorry,
So we're kind of narrowing this down to where, as you see it, our problem is whether the term in-service education, which is not defined in here, would have to be interpreted to include the ELA.
yeah. And that's where I'm going, Your Honor, because, as I said, the proper thing to look at is a reliable dictionary for the common meaning of these terms, since they're not defined. And the definitions for these professional development is defined as training that is given to managers and people working in professions to increase their knowledge and skills. In-service education is specifically defined in regard to teachers as training and education given to employed teachers throughout their career. And those are the common definitions, and ELA training clearly fits within those two definitions. There is nothing that would take ELA training out of those definitions.
So the Court of Appeals didn't explain very clearly why it thought the contract was ambiguous, but what if I could imagine an argument that in-service training is ambiguous because for the reason that you just mentioned, that there are classes that you have to take to maintain your accreditation that are classes you're taking while you're employed. So even that dictionary definition would encompass those classes, and yet those aren't classes for which teachers are compensated. So there is an ambiguity there. There are some classes you take as a teacher while you're already employed that you will be compensated for. There are some that you aren't. If we are in that world of ambiguity, does Denver firefighters and the broad management rights provision here require us to defer to the district's interpretation of what in-service training is?
No, Your Honor, I don't think we're in a situation of ambiguity in terms of in-service education. I think all in-service education, the school district right now pays for every single training and professional development and in-service education program that they require teachers to take, except ELA training. They have no trouble figuring out that all these things fit, and there's no dispute that all of these things fit under it. It's not an ambiguous term in any situation other than the district now coming here and claiming ELA training doesn't fit under it.
But maybe the district's being consistent if it's saying under 832, we're not paying for things that are mandatory. We're just like we don't pay for the continuing education that you need to maintain accreditation. That's something you take care of. And we're not going to pay for ELA because that's something after 2 years that you need to keep your job.
Your Honor, that's not the distinction. All of the trainings that the district has paid for are just like ELA training. They are required. The teacher has to take them as a condition of continued employment. If they don't, they'll be fired for insubordination. So it's exactly like ELA training. The distinction, the trainings, there are no trainings that are offered by the district, that are required by the district, that we're saying it's okay for them not to pay for those because they're related to accreditation. The accreditation thing really has nothing to do with this. First of all, it's not something required by the district. It's not something provided by the district. And it's something that, first of all, you have to have before you're even hired. You have to have accreditation just means a license. It's the same thing. So you need a license. You can't even get hired without a license. You can't expect them to pay for you to get your license when you're not even hired by them yet. I mean, this stuff is taken before you're hired. You can't even get hired unless you've already completed all those requirements. And then, of course, you have to maintain that, but that's something that you hold. You hold that license. That's your property, that license. And of course, if you want to keep it up, it's your property. You have to keep it up with your money. But this is not what we're talking about here. We're talking about requirements imposed by the district after people are employed by the district. The district is saying to people, you go to this training, you go to that training, go to ELA training, go to Common Core training, go to guided reading training, and you're going to have to do that on your own time while you're working here. That's the situation with ELA training. There is not a single training that the district offers or requires that's like that they don't pay for. There isn't just some they pay for and some they don't. That's not the case. The only thing they don't pay for are things that people take on their own. They call up a college and sign up for a course, and they take the course on their own. That's nothing like ELA training. That's nothing like any of the other trainings that they're paid for. They pay for everything except ELA training. They don't pay for things that you did before you started working there, of course not. But once you're employed, all of the trainings that they say you have to take this or else you can't keep your job, they pay for all of those, every one of them. I mean, in fact, the way the provision is written, the language about the principal that Your Honor pointed out is, I think it's a way of saying that we're only going to pay you to take required trainings. If you want to decide on your own, you want to take basket weaving, we're not going to pay for that. It's only things that we require that we're going to pay for. So it's actually just the opposite. It being a required course makes it more likely to be compensable, not less likely. I mean, they're not going to pay for you to take some course you decide on your own that's not even required just because you feel like. They're paying for things that are required. Every single one of the courses they're paying for is required for the teacher to take as a condition of continued employment. And ELA training is exactly like that.
Thank you.
Thank you. I guess I'm out of time.
Yes, you've got a little time left, Mr. Case.
Thank you, Chief Justice. So there's a statement made in my opponent's argument that nobody meets this requirement when they're hired. The record says otherwise. If you have a master's degree in educating the linguistically different, you don't have to take the ELA training because you've met that baseline requirement of the job coming in. There's also some argument indicating that the fact that teachers can be hired provisionally with the requirement that they complete the ELA training over 2 years makes some difference here. I disagree. We have this concept living in our in Title 22 in the teacher licensure statutes. Right now, there's a teacher in residence program. It's called. You come in without a teacher's license, and you're put in front of students. You're doing the same work that teachers are doing, but you don't have a teacher's license. You are required to go and do it, and I think you get, incidentally, 2 years to complete that. So the fact that this is provisional makes no difference at all. This is a requirement installed by an order of the United States District Court for the District of Colorado. There was some argument also that our argument is that if you don't list it, that means that it's silent. I mean, the issue, I'm going back to, although I hate to, I am repeating myself over and over, but it's the DCTA's problem in this case is the existence of Article 13-2 and the fact that it is separate. We don't need to list things that have to do with baseline qualifications and eligibility requirements because they're provided for under a separate section with no indication that meeting those requirements is compensable. I mean, it's like what I said before, that this whole thing is kind of being flipped if you accept the DCTA argument that the authority starts out with the district and constraints on that authority have to be given in express terms. And the question that comes to mind is, well, what are the express terms that require this to be paid? Well, there are no express terms, and it's not just express terms requiring ELA training to be paid, but there are no express terms requiring items covered by Article 13-2 to be paid. And that's really the problem. Council said that what you do in situations like this is you apply dictionary definitions, common sense definitions, but like I said before to Justice Hart, that was tried in the Nebraska case, that collective bargaining agreements with management rights clauses it's just a different animal. You don't read them like an insurance contract, like in the main case that the DCTA cited for that point.
Could I ask you one question real quick? So we got at the end to talking about in-service education at the end of your opponent's argument. So what do you think, I take it you would agree, or do you, that if it qualifies as in-service education, then that would be work for the district under whatever section it is we're looking at? Or do you disagree with that?
Well, you're asking me to make a big if it qualifies. I mean, I think my position is, under the agreement, in terms of compensation, that it doesn't qualify as in-service because it's meeting baseline qualifications under 13-2.
In which case, it's not in-service education.
Right.
Is that what
yeah,
you're
I
saying?
mean, right.
So in-service education is what? How would you define it?
Well, I mean, I think that they often have teacher in-service days, where they do complete days that are, dedicated to learning, teacher learning, where
But
the
those are
students
not
aren't there.
requirements?
But, I'm sorry?
Those are not baseline requirements?
No. For example, if you skip the in-service day, that doesn't affect your eligibility to be a teacher. I thought the question was kind of asked, show me the things, what are the things in Article 13-2, these baseline qualifications that are paid? And you didn't get an answer because they aren't.
But in-service, just your example of in-service days, I just want, Article 32 talks about extra duty compensation. In-service days are encompassed within the work week and school year. So I don't think in-service days can be what's meant by in-service education here.
Well, sure.
It's outside of the school week and school year.
If we say we're going to have a teacher in-service day at this school, that's day 185 or duty day 185, for example, the contract does it not, I left mine at my desk, but the contract lists a certain number of duty days, so if we have a teacher in-service day where all the teachers come to school and we're all going to learn about this one, subject matter, I consider that a teacher in-service day. What I don't consider in-service is the ELA training because it's a baseline qualification. There is no dispute when one of the justices asked for examples of the ELA training of the professional development that was paid. None of the examples had to do with eligibility. None of the examples had to do with teacher qualification. And that's really the distinction that we're talking about here.
Let me take you back to 813 really quick. So I asked about this before, and I think I got different answers. So is ELA training or professional development that's determined by the principal?
Well, I think you heard that it's not, because the district for a number of years has indicated that all teachers are taking, are required to take the ELA training. So the principal does not have, has no role in making that decision. Every single teacher that comes in through the door, we've got 30,000 kids who are English language learners, and we need teachers, and that's the reason for this program, to teach them.
Thank you.
Thank you, Chief Justice. Thank you.
Appreciate the arguments of both counsel. Case will stand submitted, and the court will be in recess until tomorrow morning in Fort Collins.